Okay, good afternoon. Welcome to the First District Court of Appeals Zoom oral arguments. Now before us is case 20-2227, the Board of County Commissioners for Santa Rosa County versus Home Builders Association of West Florida. Counselor for the appellants, Mr. Stewart, you may proceed when you're ready.
Thank you, Your Honor. Greg Stewart, the law firm of Neighbors, Giblin, Nickerson, representing Santa Rosa County and the Santa Rosa County School Board. This is appeal from the order imposing a temporary injunction prohibiting the collection of educational facilities impact fees within Santa Rosa County. For the purpose of the argument, I'd like to focus on the likelihood of success and irreparable harm prongs of the test for a temporary injunction and rely on my briefs for the other two criteria. An impact fee is simply stated is a charge or a fee imposed against new development to offset the cost of capital facilities that are in fact required because of that development. And as impact fees evolved as a local government home rule revenue source, most of the restrictions and regulations that deal with impact fees, in fact, were judicially created. In 2006, the legislature adopted the Florida Impact Fee Act, which incorporated, among other restrictions and requirements, that any impact fee that is going to be imposed needed to meet these requirements. Many of those requirements were the ones that had been judicially developed over the years. Though there are several requirements for a valid impact fee, the main test is the dual rational nexus test. And that was evolved through case law, and it has been incorporated into the Impact Fee Act under subsection 3, F and G. Simply stated, what the dual rational nexus test requires for a valid impact fee is that there is a reasonable connection or relationship between the development and the need for the infrastructure. And the second prong is that there's a reasonable relationship or nexus between the expenditure of the funds and the benefit to the property that pays the fee. In the present case, the impact fee that was adopted by Santa Rosa County and was the subject of this challenge clearly met that test and the other criteria that are within the impact fee statute. Now, one of the primary—
Stewart, you mentioned that you were going to talk about irreparable harm, and I have a question related to something you wrote in your brief. It's on page 49, and I quote, and you say, further, even assuming a constitutional violation is asserted by home builders, no fundamental rights are at issue, and therefore irreparable harm may not be imputed. Based on that statement, help me understand how the purported violation of a constitutional right is not the violation of a fundamental right. That doesn't make sense to me, but maybe explain it.
Well, in terms of the rights and protections that are incorporated within the Constitution, there are several categories of rights. Some have been elevated to a fundamental right status. Right to privacy has been held to be a fundamental right. That doesn't mean that there aren't other rights in the Constitution, but there are special core rights: speech, privacy, religion. Those types of things have universally been recognized as fundamental rights, both in the state and the federal level. What we were saying about irreparable harm is that the court imputed irreparable harm solely from the violation of the Constitution. But there really is not a constitutional issue at play here anymore. In the old days, prior to the Impact Fee Act, if an impact fee that was struck down—
Let me ask you about that answer, if I may, Mr. Stewart. First, and it's actually two questions, so I'll let you answer both of them, but I think I need to ask them together because they're connected. Do you have a case first that says that this constitutional right to be protected from unconstitutional taxing based on impact fees is not a fundamental right? That's my first question. And then in line with that, if there is no case saying that, how do you distinguish the Flora-Grown opinion where we say that the licensing right, constitutional right, is a fundamental right? So I'm trying to reconcile, but maybe there's a case saying the impact fees part of this constitutional protection is not a fundamental right.
Well, I do not have a case that stands for the proposition that the tax issue and under Article 7, and the issue really is in terms of if the impact fee fails the benefit test, either prongs of the dual rational nexus test, then it's deemed a tax, and taxes can only be authorized to local governments through general law. The issue, though, I think in this case is the legislature has spoken. They have in fact enacted an act, the Impact Fee Act, and so they have set forth the various restrictions. And so we are no longer dealing with the fundamental issue that whether you have an authorization from general law. There is one. It has been adopted since 2006. And so you are no longer imputing from a constitutional violation, but a statutory one. And that is the fundamental distinction between what the trial court did, which is in fact ignored these are all statutory requirements now, not constitutional requirements.
What, I'm sorry, go ahead.
No, please, Judge Day, please go ahead.
Well, I'm still, so what would you say about Flora-Grown? And I quote, even if there were a remedy at law, the law recognizes that a continuing constitutional violation in and of itself constitutes irreparable harm. I guess you would say this was not a purported constitutional violation because there's this statutory mechanism?
Well, in terms of the impact fees, I would, and again, the prohibition in the Constitution is that if you have a revenue source that fails to meet the standards for a fee, it is then becomes an unauthorized tax. The legislature has now set forth the parameters for a impact fee, and it is the violation of those conditions that is now at play and no longer a constitutional right. I agree with you in terms of the distinction that Flora-Grown, it is somewhat kind of in the middle between what I would consider fundamental rights and other protected rights under the Constitution. But in this case, the irreparable harm, you don't even need to get to that argument because the issue is what is the violation that is being alleged? And the violation is a statutory violation, not a constitutional violation. It doesn't matter at that point. So one of the other issues that, and I think it's important to recognize, is that the trial court fundamentally applied the wrong standard in evaluating the impact fee ordinance. And the trial court took the position that the record in essence was closed at the time that the Board of County Commissioners adopted the impact fee ordinance, and that no other evidence could be presented other than was presented to the board.
Well, counsel, on that point, the appellees rely on the text of the act itself to establish that closed world. So how do you distinguish, or how do we get around the express language of the text referenced by the appellees?
I don't believe that language stands for the proposition that they're saying it does. And all it's saying is that when the impact fee is adopted, these are the certain criteria. That is a significant difference between what you would review in a legislative act as a court, and what it basically saying on its face is that you need to do these as part of the impact fee study and part of the analysis, part of the ordinance. So I do not believe that the language that they cited in the impact fee statute in any way implies that these impact fee ordinances are treated differently than every other ordinance adopted by local governments, which
Yeah,
is
well,
in
I
fact,
couldn't understand why there was a need for an evidentiary hearing to begin with if we were in a closed world, if the court, and we're limited to what was actually presented to the board.
well, and that was that was one of the issues that we became aware of subsequently, that the evidence was presented. They presented experts. If in fact it was a closed world, as they were arguing, then the question is, why were they allowed to put on expert testimony that did not appear in front of the Board of County Commissioners? The reality is that as a legislative act, we are entitled to present matters in front of the Board of County Commissioners. We are also allowed to bring forth and present evidence that will address issues that are raised in a challenge to an impact fee. And so to suggest that they are somehow closed, it really is inconsistent with established law that has very clearly designated legislative acts as something that you look at de novo. You do not have the exact record. There can be new evidence presented, and that is well-established law.
Counsel, before you, I'm sorry, before you turn, or we have to turn to Appalee's case, I wanted you to touch on the special benefit language that comes from the Aberdeen decision that appellees rely on heavily in their answer brief.
Yes, first of all, two things about that. The court in Aberdeen, of course, Aberdeen is a very specialized case because it really was dealing with a restricted use for a subdivision. They are in essence suggesting that Aberdeen is the new standard, the use of the special benefit, which is generally considered in the concept of special assessments as opposed to impact fees. What we would point out is that when the legislature adopted the dual rational nexus test, they rejected the Aberdeen articulation of what that test was, a special benefit test. In fact, they are using the language which was derived from the Dunedin cases, which were the Florida Supreme Court and which both sides have cited. We believe that Aberdeen is a very narrow case dealing only with the issues of restricted use and how that would apply in impact fees, and that there was not a new recreation of the dual rational nexus test.
Counsel, I understand your position. Your position is that the trial court was not limited by the information that was presented to the board before the ordinance was passed in the proceedings with law. Is that correct?
Well, the standard applied by the trial court was even more restrictive because they not only limited it to the matters presented to the board, it had to be actually in the study itself. And there is no case and no statute which has ever said that the study has to include not only all of the calculations, all of the backup, but all of the other factors that may be considered in making the decisions by the school board in Santa Rosa County in this case. That is a very restrictive view in terms of what must be in the study.
Did the trial court
Several of the evidentiary matters were rejected simply because they were not in the study. The issue of attendance zones, which was the primary function in terms of why there are no districts.
Along those lines, the trial court considered the testimony of Dr. Fiskin.
Dr. Fishkind?
Yes.
The Dr. Fishkind's testimony was given. The court, I believe in the order, somewhat did not give it much credibility.
And how does his testimony support your position in reference to the dual nexus test?
Well, Dr. Fishkind's testimony was, in addition to the county school board representatives, he talked about how the benefit is derived by the House. And really where we're looking at in terms of the impact fees is that school districts utilize attendance zones. And attendance zones allow the modification to make sure that there's available capacity to, in fact, address the needs of a particular community, provide the student stations. So in fact, students will be able to attend school and not in an overcrowded situation. Dr. Fishkind explained how all of those factors interrelated to demonstrate the capacity that's being built and the benefit that's derived from those houses that pay the impact fee. And my time is kind of out, so I will reserve whatever time I have for the rebuttal. Thank you.
Thank Mr. Stewart. I'm going to extend your time by 2 minutes for your rebuttal. And of course, I will do the same for Mr. Bell.
Thank you.
Thank you, Your Honor. I'm Ken Bell with the Gunster Law Firm, appearing on behalf of the appellees. Judge Jay, on the irreparable harm issue, I agree with you, and that's why we cited Flora-Grown, because I think it's exactly on point, not only to irreparable harm, but if you look to the damage issue, you have a local government that has sovereign immunity, and there's no way for the appellees in this case, should they prevail, to recoup any damages. And
Mr. Bell, what damages would they be entitled to beyond a refund of the fees that may have been collected already?
Lost sales, loss of income from the sales of home. Mr. Flynn testified he sells homes in the lower need, a broad array, but poor people cannot afford $5,000. Let's say you're building a 2-bedroom, 1-bath house, and you have to pay a $5,000 impact fee, and the house is a $150,000 house. Those are numbers I've just made up, but just to answer your question, that it's a huge fee for somebody to pay like that. Or let's say it's a mobile home that somebody's putting on the back of their lot for their parents. It's $4,500. That's a lot
From
of
the
money.
appellee's position, would you agree that that loss of business generally will not support a finding of irreparable harm?
If it's can be compensated. I don't agree in the case of where it's sovereign immunity, and I refer back to the Flora-Grown case where this court held that because the county and the school board are protected by sovereign immunity, then that would allow and be a basis, because in Flora-Grown case, the Department of State had the protection of sovereign immunity, so Flora-Grown could never recoup the damages. So I think that the judge's order is based on competent, substantial evidence and should be enforced on that basis. I think the key thing in this case, regardless of, because I think the only limitation the trial court made is try to correct defects in the information presented and relied upon by the school board once it was brought up. So there was no, Fishkind testified, Bowles testified, Mr. Harrell testified through the whole process. So there was deliberation on the information, the study, and what was presented to the Board of County Commissioners.
But getting back to the irreparable harm element of the temporary injunction, is the remedy generally in these types of cases a refund of the monies paid?
Well, I don't know. There's no case law, as Judge Jay said, there's no case law on it. And just a refund of the money deposited doesn't cure the harm.
Mr. Bell, let me, were you finished with your answer? If you're not, I can wait a minute.
I'm finished there. I'd really like to get to the special benefit issue, because that's the real issue here, because it's undisputed that these fees do not provide any special benefit to the fee payers that is not enjoyed by other non-fee payers, which is the standard in Aberdeen, Collier County, et cetera.
And certainly we want to give you time to deal with that. I do have a quick question. You may not have an answer for me, but I am curious about it, simply because there aren't a lot of cases dealing with this irreparable harm component where there is an underlying purported constitutional violation. As you well know, irreparable harm is the jurisdictional standard for a petition for writ of certiorari. Same term. Are any of those cases, that body of law, is that germane to our analysis, or is that completely a different analysis point?
I think it could be, but we relied on Flora-Grown, Tobin, and the Cunlin case because we felt it was they all dealt with the constitutional right. And I mean, our country got formed over an argument over taxation without representation, and the violation or imposition of an unconstitutional tax has to be a fundamental violation of a constitutional right, not to be taxed or to be taxed without proper authority by a local government. I don't think, and see, the whole problem is it's hard for individuals to come and attack something like this because it takes an association and these people to be able to pay for fees. You know, you got somebody paying $5,000 for one home, they can't mount the attorney's fees and the cost to challenge an impact fee like this because of the resources available to local government. That's not available because you don't get attorney's fees, you don't get damages or anything, you may just get reimbursed. So that's why you see a few cases. Aberdeen was decided in 2000. And despite what the opponents say, it dealt with 5 issues. Issue number 4, 2 pages, 134 and 135 was the parties also dispute the proper application of the dual rational nexus test. And the court unanimously, with very strong language, said, you know, you had Volusia County doing what Santa Rosa County is doing here, arguing for a county-wide standard versus a subdivision-based standard. And what they held emphatically, if you went to a county-wide standard that didn't provide a special benefit not enjoyed by others, it would eviscerate the dual rational nexus test and obliterate, these are the verbs used, eviscerate and obliterate the distinction between a constitutional tax and a fee, and a proper fee. And that's exactly what the county has done. If you go and look at Collier County, a case, well, first, the opponent never mentioned Aberdeen substantively, yet it was the most recent case. Prior to that, you had Collier County. They don't mention that in any of their cases. Another unanimous decision the year before Aberdeen in Collier County, and they said, while the services to be funded by the assessment may be population sensitive, and that's what you have here, you have population sensitive services, schools. The provision of these services provides no direct special benefit to the improved property. Therefore, in that case, the governmental services fee was held to be unconstitutional. You have the same thing here. You have population growing. So the county and the school is having trouble garnering the resources they believe they need. So they're looking for alternative methods to do that. And so they chose the impact fee in this case. But the dual rational nexus test, as clearly articulated on page 134 and 35 of Aberdeen, they say the local government must demonstrate reasonable connection between, 1, the need for additional capital facilities and the growth in population generated by the subdivision, and 2, the expenditure of the funds collected and the benefits accruing to the subdivision. And what Santa Rosa County admits in this case is that there is no special benefit to the fee payers in this case. And if that's true, then you would be in violation of the clear statement in Aberdeen. And let me go, what the reply brief is, if you look at page 4 and 5, they rely on a quote from St. Johns County to try to say our position is irrelevant. But what they failed to say is that quote is specifically addressed in Aberdeen. On page 135 of that opinion, they say, Volusia County highlights the dicta in St. Johns County as credible support for its position. That's the same language that they go on to quote that the county relies on in its brief. And they admit, they said, at the very least, the dicta created ambiguity in determining the application of the test. But how did they answer that? Nonetheless, our repeated citations to the special benefit standard and our interpretation of St. Johns County demonstrates that we did not abandon the subdivision-based standard. Indeed, imposing a county-wide standard, which is happening in this case, would eviscerate the substantial nexus requirement. This nexus is significant. Why? Because of the distinction between taxes and fees. And then they go in and discuss that distinction. And they say fees by contrast must confer a special benefit on fee payers in a manner not shared by those not paying the fee.
Oh,
Thus,
counsel,
a liberal-
let me
I'm
ask
sorry.
you about the subdivision language, because I don't think it's an issue in this case that parsing it down to a subdivision level is appropriate. Is it? I mean, I think your own expert said that would be ludicrous. So
Well-
what meaning do you derive from subdivision analysis here?
Well, the fees developed up for water and sewage and roads and parks and things like that. And the school system has grabbed onto that as the way to get additional funding. But they can't, as a matter of constitutional law, separate the connection that the test requires in order to be a valid fee versus an unconstitutional tax, that there be that special benefit not enjoyed by others. The way I look at it, the act was amended for credits and other things, and they referred to zones or districts. In this case, the first study, as you saw in the brief, said there was a difference between the north, growth in the north and growth in the south. I think in another case, if it comes up, if you had a zone where you had several subdivisions or sub-district of the district, which is the whole county, a district where you have rapid growth, let's say like in Navarre, the south end of Santa Rosa County, that you could do it that way. I don't think it has to be subdivision by subdivision. That's the language in this case, but it has to be directly related and proportional to the development. If you accept their argument, then the county could come back and argue for the same needs as to fire, emergency services, roads, and any other thing that's normal governmental service. And what the court has made clear, that's a general service and that's a benefit to the whole, to everybody. And the county has not contested. In fact, they agreed there is no special benefit in this case other than general access of everyone to the schools. That's what Mr. Bowles testified to. That's what Mr. Harold said. We don't care where the money comes from, whether it's ad valorem tax, sales tax, or impact fees. We're going to apply it anywhere in the county where we think it needs to be. So if you get money from Chumuckla, it may be spent on a school down in Navarre. That is a tax by definition, by unrefuted case law. And the county wants to ignore unanimous decisions by the Florida Supreme Court that are directly on point. And you cannot say Aberdeen is an aberration because it was a subdivision that was limited to adults only, because they answer the legal question and they do it over 2 pages, and they make clear that a county-wide standard is not appropriate for an impact fee.
Yeah, it seems to me, though, that there is a distinction to be made in Aberdeen, because as you just pointed out, that involved a mobile home community with a restriction, like no children could live there ever. Whereas in this situation, children may come and go in a particular house over the life of the house. So that does seem to be different in kind from what we were dealing with, where the court was dealing with in Aberdeen.
Go back to Collier County, which they ignore. It's the same thing. But the example I used at the trial court, let's say you live in Chumuckla or live up in Jay, which in the very north end agricultural area of the county, you own 10 acres, you put a mobile home in there because your parents are getting old, you pay a $4,500 fee and you get no benefit from it. There's no assurance of any benefit. And it could be used, as Mr. Harold testified, if it was Chumuckla, it could be used for a school in Navarre. What special benefit not enjoyed by other non-paying is it? There's none.
But didn't St. Johns County, though, acknowledge that some people are going to have to pay for a school impact fee, and they may not ever have a child that attends school, and that's okay. I mean, that's part of the process. And so are you saying that Aberdeen receded in some way from those broad statements in St. Johns County?
It clarified because they dealt with expressly, they mentioned St. Johns County several times. And they say, moreover, this court in St. Johns County reaffirmed the Dunedin requirement that the fees must be spent to the benefit of those who have paid the fees. And they go on to say, we expressly repudiated a countywide standard for determining the constitutionality of impact fees. So they deal extensively in Aberdeen with St. Johns County, and even acknowledge that St. John County itself agreed that there had to be that special benefit. So it's the burden of the government to prove by preponderance of the evidence that there's a special benefit to the people being required to pay these fees. And it's not on new development, it's on any new residents anywhere in the county to collect money to be spent in a way that there is no assurance or guarantee that the person paying the fee for the impact of them building their one home in any way benefits them, other than the general benefit that every other taxpayer in Santa Rosa County has. And that is by definition a tax, not an impact fee. It's
Counsel,
not.
is there any evidence in the record in this case that these fees will go to improving existing facilities?
No, they're for new facilities. But as Mr. Harrell said, and I'll quote, the school district intended to spend the fees in the same manner it spends ad valorem taxes and local option sales taxes, i.e. to treat the district as a whole and use the impact fees anywhere in the school district or county where new facilities are needed. It's not proportional from that standpoint. We treat the district as a whole. And so, and he even characterized the benefit a payer of the fee would receive as, quote, the general welfare of the citizens of Santa Rosa County. That's by definition a tax, not an impact fee. Because as in Aberdeen, they define the tax as noted in Collier County. There is no requirement that taxes provide any specific benefit to the property. Instead, they may be levied throughout the particular taxing unit for the general benefit of residents and property. Fees, by contrast, must confer a special benefit on fee payers in a manner not shared by those not paying the fee. And Santa Rosa County agrees, testified. The only competent substantial evidence is from Bowles, from Harrell, from our expert witness, from Fishkind, is there is no special benefit. Consistent with
Mr.
the
Bell, I
standard.
have one more quick question for you before you conclude. The appellant suggests there will be an impact on school choice, an adverse impact on school choice and attendance rezoning, I guess, if we were to adopt a geographical sub-district method for impact fees. If you could respond to that.
Yes, that's an issue for the legislature and not for the court. The issue for the court is this court, because you have two unanimous decisions by the Florida Supreme Court saying that it has to be more local based and it cannot be a countywide standard. You have that as clear as can be from a unanimous decision of the Florida Supreme Court. So they may need more money, but they cannot impose an unconstitutional tax.
Well, I know. I guess my question is there going to be an impact on school choice? Will parents be allowed to utilize school choice if we affirm the trial court's decision here?
I don't see why not. They wouldn't be, because the county and the schools can seek, they can increase ad valorem taxes, they could get sales tax, there's other funds, but there's no evidence, and it was their burden to prove that if this impact fee wasn't passed, then there would be an impact on school choice. In fact, they argued school choice the other way around, saying that because of school choice, that student up in Jay could go to school down in Navarre or something like that. But
Counsel,
there's no evidence. Yes, sir, I'm sorry.
As a follow-up question to Judge Ray's question, is there any evidence in the record disputing Dr. Fishkind's testimony that treating the North and the South as portions of the county differently would require different trust fund accounts, would inhibit school choice, and would complicate rezoning?
There was evidence by the expert, Dr. Bice, who is the preeminent expert on this, as the trial court recognized, that it could have been done as recognized before, have the Northern District and the Southern District. That was done in the April study by Mr. Bowles, recommended 2 different districts. And as you see in the facts of the case, they did a new study in December, didn't provide it to the Board of County Commissioners prior to the ordinance approval, and that recommended 1 district. And the only reason that they did it was that's the way they wanted to do it. But it wasn't that they couldn't have separate districts and meet the requirements. And so I think you have a very long, as Judge Jay, you served as a circuit judge, you know the amount of time Judge Dickey took to have to write an order like this. And she spent 5 pages just on the irreparable harm issue, and it wasn't as flippant as my opponent suggests in all 3 different aspects of the irreparable harm. But she spent page after page summarizing the expert testimony, and her findings are supported by competent substantial evidence, and her legal conclusions are supported by the law. There's a reason Santa Rosa County ignores Aberdeen and doesn't talk about Collier County alone, and tried to use a quote that the Florida Supreme Court dismissed in Aberdeen from St. John's to try to support their position. And that is because they can't take Aberdeen head on, or Collier County.
Thank you, Mr. Bell.
Thank you.
Madam Clerk, if you would please extend Mr. Stewart's time, the amount that we went over for Mr. Bell.
Thank you, Your Honor. Let me talk about Aberdeen very quickly. And the issue that really was being addressed in Aberdeen is that we clearly had a development that had an age restriction, and so they would not generate children as if a non-restricted community. And therefore, they did not have an impact on the school system. The argument that the county made in Aberdeen was that if they meet the general countywide benefit, then that is sufficient. The court basically said, no, if there are circumstances about individual subdivisions or development that would impact on their benefit that they derive from this, you have to address those and you have to take those into account. And in fact, the ordinance in question by Santa Rosa County expressly carves out that age-restricted subdivisions shall not have to pay the impact fee. But that is what really led to this kind of countywide standard versus the subdivision language. It was attempting to take the special circumstances of the age-restricted mobile home park. And the county was suggesting that if we can meet it for the whole county, that's all that matters. Court said no, and rightly so. We're not saying that you don't look at the circumstances of the individual properties. What we are saying is that the benefit that is going to be derived from the school impact fee is the capacity that will be built. We have facilities to serve the students that currently exist in Santa Rosa County. Every time a new house is built, there is now a new greater generation of students that was not there before. And the purpose of the impact fee is simply to make sure that they have capacity. Now, Mr. Bell is somewhat suggesting that each subdivision gets its own school. That's ludicrous. What really is going on here is that that impact fee is building capacity to the system as a whole. And then the school attendance zones are used to make sure that those students in that new subdivision, in that new house, have a student seat to actually attend school at. And that's what they're paying for. That's what they're paying for. So all of this about special benefit is really missing the point. What we're talking about is, does the school have the capacity to serve that child that is in that single family home? And the fee that they are paying, that impact fee, goes to the construction of that student station to serve that house. Now, they don't have to put the school student station outside their subdivision. They look at they can merge that into the capacity as a whole. And that's what every county in the state of Florida that has done school impact fees, that is how it's done. It's the added capacity that is being acquired. That is the benefit that is being provided. Secondly, talking about the benefit, this impact fee has just been imposed. We haven't spent one dime. And so basically the appellees in this case are saying, well, there's no showing that that money's not going to be spent. Well, what the case law has shown us in the Dunedin case is that you look to the ordinance itself and the ordinance's restrictions on the use of that money. And this ordinance here contains numerous restrictions to guarantee that that money is only going to building growth-related improvements to provide.
Council, are these funds currently being held in escrow by the county?
We both the county and the school board adopted resolutions that said we will escrow this money during the pendency of the litigation. However, when the court issued the injunction and once the bond was set, which was $250,000, then they stopped paying the impact fee. We have the money in escrow that was collected prior to the injunction taking effect. Now, in terms of Judge Lewis, let me go to a question that you raised that about the ability of school choice. If you look at the impact fee statute, it requires that a trust fund be established for the housing of all of these impact fees. And that is to guarantee that it is being spent in the districts that in fact paid it, if you have districts. So you are not going to be able to move from district to district because there is a prohibition as referenced in the St. John's case about allowing attendance at schools that were not funded by the people who pay the impact fee. And when you break up a district and create a district, you have in essence two pots and they have to be kept separate. That will impact on school choice. It will impact on the ability of students to attend other schools in order to do special programs, whatever the case may be. And that is why the school board decided that districts do not work based upon our operational requirements and to maximize the freedom of students to move throughout the district.
Mr. Stewart, yes. Thank you so much. Mr. Bell, thank you as well.
Thank you.
I hope you both have a good afternoon. We're going to stand in recess.
Thank you, ma'am.
Thank you.